2020 is an election year, not just for president, but also for some important California ballot measures, complicated ballot measures. Welcome to Take Notice. I'm your host, Janet Fogarty. I'm looking forward to a much clearer understanding of my ballot with our esteemed guest, Judge Quentin Kopp. Judge Kopp was appointed to the bench by Governor Pete Wilson in 1999 and served in San Mateo County until he retired in 2004, and then immediately after he retired, he served as an assigned judge throughout the state of California by the order of the California Supreme Court. Judge Kopp was elected to the state Senate in 1986 as the first independent in 100 years to be elected to that position as a non-incumbent. He was then re-elected in 1990 and again in 1994. He was chair of the Senate Transportation Committee, and from that powerful position was very influential in getting the BART extension to San Francisco International Airport extended all the way into the airport instead of stopping 1 mile away, as had been promoted by local authorities and the then airport director. Prior to his rise to state office, Judge Kopp served on the San Francisco Board of Supervisors, from which he held a seat on the Metropolitan Transportation Commission, serving as chairman of the board from 73 to 74, and he served on the Golden Gate Bridge District Board from 1977 to 1986. Judge Kopp also has served on the California High-Speed Rail Authority Board, serving as its chairman in 2006. He's been a practicing attorney since 1986 and an active leader on the State Bar and American Bar Association. Judge Kopp, thank you for your long history of distinguished service to the people of the peninsula and the state.
It's been mostly a pleasure.
Today, we want to pick that very erudite brain of yours to explain to our viewers about these ballot measures coming up on our March ballot and our November ballots. So there's confusion about this Proposition 13 on the March ballot. And does it have anything to do with the Proposition 13 that sets our property taxes?
No, it doesn't. State ballot measures are submitted with numbers, unlike local ballot measures, which are submitted with letters of the alphabet. This is a general obligation bond issue, which requires just 50% plus 1 in order to be approved by the electorate. As indicated, the principal amount is $15 billion. It will, of course, bear interest, and it will be a 35-year bond, meaning that interest will accrue for 35 years every year. The interest yield or payment is 4%, and that means by the time the 35 years have ended and the bondholders have been paid their investment, it will have cost California taxpayers something on the order of $26 or $27 billion. The proceeds are destined for special fund use. The proceeds of the $15 billion will not go into the general fund of the state of California. Those proceeds will be placed in a special fund to be allocated among public schools at all levels, community colleges, the California State University system, and the University of California system.
So could that money be used for salaries, or it's only for construction?
It is prohibited for use for salaries. A general obligation bond is borrowing. The state of California is borrowing $15 million, and the state of California, through its taxpayers, will repay the $15 billion together with interest at 4% per year for the next 35 years, as stated, if it's approved by a majority of the voters on March 3, 2020. And the proceeds of a borrowing through a general obligation bond under the law are not supposed to be used for day-to-day expenses like salaries.
Thank you, Judge. What is the breakdown of how the money is going to be allocated among the different schools?
About $2 billion will go to the community college districts, $2 billion to the state universities, $2 billion to the University of California, and then the balance to public schools of all sorts and grades, including some allocation to charter schools, which was designed, I am sure, to secure the support and the votes of people who believe in charter schools.
So I understand there's $9 billion in bond money to reimburse the state general obligation bond expense revolving fund. Can you enlighten us about what that fund is?
That is not a cost of doing business reason for use of the proceeds of the bond, but that's what the legislature does in order to make good on previous bond issue borrowing, which requires some financial assistance occasionally. And so that's a large amount of the $15 billion. I can't remember in watching California general obligation bond issues since 1958 any such comparable provision.
So that's pretty extraordinary.
It is extraordinary.
So the measure also authorizes 5% of the funds to be used for administrative costs. So 5% of $15 billion is $75 million.
That is an unusual provision also. Administrative expenses can eat away at the proceeds of a borrowing. And the reason for that clause, obviously, is to allay the antagonism or the fears of voters and taxpayers that it'll be consumed by administrators of the money. And therefore, a 5% of the $15 billion is included as a limit on how much can be spent.
So it's a safety cap, so to speak.
It is, in order to give confidence to voters that more than that many dollars of it will be eaten by administrators and bureaucrats in the educational systems of California, from kindergarten through doctorate degrees.
Who supports the measure and who opposes it?
The teachers' unions and unions that are allied with the teachers' union. The California Teachers Association is probably the best known. There are also some other entities like contractors who will derive money from construction and maintenance work that is paid by the proceeds of the bond issue, and of course the unions for the construction and maintenance businesses, which will have to be engaged by school districts and universities and community colleges to do the work that the borrowing provides can be done financially.
So who opposes it?
The usual taxpayers organization, the California Taxpayers Association, opposes it, and other entities of the type which at least pride themselves on protecting taxpayers and having a belief in fiscal discipline as far as taxpayers' monies are concerned.
Well, let's talk about the November election. There are several measures that have qualified for the November election, and probably one of the most confusing for people is a key initiative that's a constitutional amendment affecting property taxes and our beloved Prop 13, the California tax on commercial and industrial properties for education and local funding initiative. What are the basics that our viewers should know about this?
For assessment purposes, this ballot measure in November represents splitting the so-called assessment roll between residential real property or real estate and commercial real property or commercial real estate. It has long been argued that there is a distinction. You and I can't make money off of the home in which we live as real estate until and unless we sell the property, assuming the price is higher than it was when we bought the property. A commercial real property or commercial real estate, however, does generate money. And it generates money in tenancies, and it generates money in terms of the employees of its own who may provide services which result in profit, commercial enterprise profit. And there have been for years people who argue that while the June 1978 adoption by voters as a constitutional provision, coincidentally Article 13A of the California Constitution, was unjustified as far as commercial property was concerned. In 1978, people, especially people who own homes who were living on fixed incomes, like Social Security or a pension plan, were being affected adversely because of the increasing assessment of their properties. Even in the 1970s, the value of homes was increasing. The income of the owners, many of the owners, thousands and thousands, was not increasing. And that was the basis as a practical matter of Proposition 13. The argument as stated is that that reasoning does not apply to a corporate or other owner of a commercial building. And there are two versions of what will be on the ballot in November. The first version, which was altered after the expenditure of $3.5 million by the sponsors, and these sponsors consist in large part of historical opponents of Proposition 13. Again, teachers, unions, and school administrators, for example. That exempted a commercial property that was worth less than $2 million, market value. The version on the ballot in November, which arose as a new and substitute initiative in effect, is the exemption only will apply to less than, or only, with the exemption will be under $3 million, and that apparently is to attract more support for it because it's opposed by the California Chamber of Commerce. It's opposed by the Howard Jarvis Taxpayers Association, which was the sponsor of Proposition 13 in June 1978, and it's also opposed by the California Taxpayers Association.
So when people talk about this being a split roll initiative, what does that mean exactly?
It means that instead of having one summation of all real estate parcels in the county, in a particular city or otherwise, including farm property, that you have two roles. One role will be for residential real estate, the other role for commercial real estate.
So the residential real estate would still fall under the Prop 13 rules we know.
That's correct.
And the commercial?
The commercial property would not. The residential and commercial property at the present time has value increase of only 1% per year for assessment purposes. But if this measure passes, and again, it requires a majority plus one person, one voter, to be enacted and placed in the state constitution, both in Article 13A and also in Article 18, a commercial property with a market value today of over $3 million would be reevaluated every year, taking effect as of the fiscal year 2022-2023. Government fiscal year is not by the calendar, not January 1 to December 31. It's July 1 to June 30th of each year.
So say Hillsdale Shopping Center, which has been in the Bohannon family for years, probably has a low tax base, I'm guessing.
It has a tax base of what it was worth on the market in 1978.
And so it would go up to what it was worth
in the year 2022, 2023.
And how do you think that might affect brick and mortar retail sales statewide?
It depends on the value of the building in which their store or their shop exists. If it's in a building which has a market value of under $3 million, it should have no effect. If it's in a building with a market value over $3 million come 2022, 2023, I would think that logically, as a matter of human behavior, the rent will be increased because the owner of a building has to at least cover expenses, and one of those expenses is the property tax paid to the county every year.
So a lot of commercial buildings pass through any kind of increases in property tax as a form of common area maintenance charge to their commercial tenants. So I imagine this could affect consumers and businesses and large employers who might be affected by this.
That's part of human nature. If I rent space in a commercial building deemed to have a market value of over $3 million, my lease probably has some clause which mandates that any increase in property taxation is shared by the tenants of the building, including me. I think it'll have a deleterious and weakening effect upon so-called brick and mortar businesses, which are already beset by the competition of online businesses selling products of all kinds.
So the state legislative analyst says this will increase property taxes by $7.5 billion to $12 billion every year. Where is this money going to go, this new property tax revenue?
It's going to go for special purposes. It's going to go for educational facilities and for other special operations of government, both county and state. A property tax payment academically and theoretically and historically goes into the general fund of the taxing entity, and a property tax is assessed by the assessor of each county, including San Mateo County, each of the 58 counties in the state of California. This defies that logical and historical use of property tax income and revenue, because it specifies what the money should be spent on. Now, that has the advantage of encouraging educational facility administrators, organizations, certainly the California Teachers Union, always demanding more money for schools and for not just their own salaries, but also for the maintenance, for the repair of structural defects in school. It's not entirely precedential. It certainly represents a deviation from the normality of the use of property tax money in the state of California among the counties.
So there's $1 billion earmarked here for administration costs. It says in the measure, such as the costs of the assessor having to go out and reassess all of these properties and then reassess them and then reassess them and then reassess them, because there are costs associated with all that kind of administration. But it goes into the state funds, as you mentioned. Do you have any idea how they came up with $1 billion is the right number?
I don't have any concrete idea. I surmise they asked each of the 58 assessors in the 58 counties of California what they estimate the expense of appraising commercial property every year will be. $1 billion is an unprecedented amount of money out of a general obligation bond issue or out of the property tax receipts to use in that respect. And it's a cost which probably won't be advertised in the campaign advertisements, which you'll see after the March primary is concluded.
The governor has been quoted as saying he expects the state will have a $21 billion surplus this year. Do we need this $12 billion more?
I surmise that's a request for an opinion. And my opinion is no. We have not only an estimated $25 million surplus, but there's also about billion. There's also about a $5-6 billion money in reserve fund by state law. And the total of that certainly should be a source of spending money without borrowing money with respect to the bond issue that's on March 3rd, and without the need to spend $1 billion theoretically to reassess commercial property every year. I was for probably 30 years a believer in the split roll. When I was a state senator, I introduced a bill to apply the property tax differently to commercial real estate. One bill I introduced would have caused a reassessment every time 50% or more of a corporation's common stock changed ownership. That would then trigger a market value appraisal by the county assessor if the building was owned by a corporation. The bill didn't apply to a commercial building owned by an individual or an association, unincorporated association, for example. I thought it was logical because Proposition 13 itself from June 1978 provides that when you sell your home, the buyer will see a reappraisal to market value for the cost of the purchase price, which is logical and it's easy to do. But that bill never survived the Senate Revenue and Taxation Committee. I have since changed my mind, especially with respect to the proposal which we will vote on in November, because of the way that it's structured, for example, so that property tax revenue does not go into the general fund of a county for distribution to various governmental districts, including cities and school and community college districts within the county. That's a fundamental governmental practice and custom, and this violates it in its entirety. And so even though I still believe in a split roll, the proceeds of which from commercial property would go into the general fund of the county to be distributed, I don't believe in the propriety of the measure which we will see in November.
Well, thank you, Quentin. You've really helped to shed light on these issues. They're very complex. We appreciate that you've come to help us with these. We hope you'll come back again when we take a look at the other issues that are on the November ballot coming up later this year. So,
thank you. I accept.
Great, great. So thank you all for listening today, and we want to remind you that it's important to understand what you're voting for, but it's very important to vote. You know, democracy is not a spectator sport.
Mm-hmm.